I now welcome Rukshad Davar, who is a partner and head of the M&A Practice Group at Majmudar Partners, where he focuses on M&A, inbound investments, restructurings, joint ventures, corporate and commercial matters, competition and antitrust, and direct tax. Rukshad has over 23 years experience in these matters and has successfully led and advised on complex domestic and cross-border mergers, acquisitions, restructurings, joint ventures, strategic investments, asset sales and purchases, corporate advisory, and direct tax and tax treaty matters. He was previously with Jones Day. We welcome Rukshad and thank you again.
Thank you. Thank you, Amelia, for this introduction, and thanks to ACC for getting this event organized, and special thanks to Kerry as well for organizing this. Good morning to all of y'all, and thanks for taking the time to attend this presentation. This is the second second series that we are doing for ACC San Francisco Bay Area. So the topic, as it suggests, contracting in India. We are going to take you through some very important principles of contracts and what you all need to be mindful about whilst executing contracts and dealing with Indian parties and Indian counterparts. So directly diving into the presentation, the first slide is on general principles of contracts. So the Indian legal system is largely based on the common law system, and we inherit a lot of our old laws from the UK, and there are certain laws that even go prior to independence that we are still following. To name the important one is the Contract Act 1872, which imbibes a lot of principles from it's a pre-independence legislation, and all the principles of contract is regulated and governed by the Indian Contract Act. Now, an important point that needs to be borne in mind is that there is no statutory limitation or restriction on the choice of law governing a contract under Indian law. Okay, so parties are free to use the governing law as they deem fit for contracts. Obviously, if there are two Indian parties, I mean, and two domestic parties, then obviously Indian law would be chosen as a governing law and the law of the contract. If either party is a foreign national or a foreign entity, then there is flexibility on choosing the choice of law. So that can be borne in mind in terms of whether you want to have it governed under US law or any other law, as a matter of fact. However, an important point in this regard that needs to be borne in mind is that if foreign law is used in a contract, then that needs to be proved before an Indian court. If the contract is to be proven before an Indian court, say for example, if there is a dispute that has arisen under the contract, then you would need to prove and prove the foreign law of that contract before the Indian courts. Now, contracts can be, there's no, clear-cut prohibition that would prevent you from having an oral contract, but normally we have seen only written contracts happening out here. So, although the flexibility is there to have oral contracts, but those, since they are difficult to prove before courts and before arbitrators, written form of contracts is most preferred. So under the Indian Contract Act, just to take you all quickly through the essential elements that would be there, even any other law, as a matter of fact, even the UK or in the US. So essential elements of a valid contract is that it has to be out of free consent. Parties have to be competent to contract. There has to be a lawful consideration, and there has to be a lawful purpose or an object for that contract. Then also contracts which are executed on the basis of coercion, undue influence, fraud, misrepresentation, those can be voidable at the option of the parties whose consent is not being taken. Also, if both the parties are mistaken to an essential fact of a contract, that contract can be held to be void. An important point that needs to be noted is that an agreement which provides for a restraint of legal proceedings is invalid. We have recently come across a situation, where one of our clients, they have wanting to put across an arbitration agreement in the contract. But with that arbitration agreement, what the client intended to, wanted to achieve was to, to limit the appeal from an arbitral award. Now, under the Arbitration Act and under Indian law, an arbitration award can be appealed to a limited extent. So if you are going to take away that right in a contract which prohibits a party from, instituting legal proceedings, that would be invalid. So that's an important point to bear in mind. Now, there are certain restrictive covenants that are, very forthcoming in contracts, and that we see it on a regular basis, such as, restraining people from starting competing business or for working for a competitor, soliciting one's customers, recruiting others' employees, as well as disclosing trade secrets or confidential information. So a thumb rule that needs to be kept in mind is that, non-compete, non-disclosure, non-solicit clauses, in terms of they are restrictive covenants, and they are not held to be, non-competes are not held to be valid post the term of the contract. However, during the term of the contract, they are held to be valid, but not for share purchase, share sale agreements. These are held to be valid and enforceable during the period of an employment contract. So, very many times we have been faced with these situations where the law doesn't allow you to have these restrictive covenants under a share purchase agreement or an investment agreement. But the way we seek to enforce these restrictive covenants is by including it in the employment agreements with those key promoters or founders who are going to continue in employment. So they can be held accountable for breach of non-compete provisions during the term of the contract, but those are not held to be valid and enforceable after the term of the employment contract. So, another point to be borne in mind is that any covenant that restricts any person from carrying out a lawful trade or business is void under Indian law. So I have already touched upon the first point in the next slide, that it's enforceable under the non-compete clauses are enforceable under employment agreements, and whereas non-solicit clauses for solicitation of employees, they are valid and enforceable during the term of the contract and even post termination of the contract. But however, non-solicitation of customers, that would follow the same rule as a general non-compete clause, which would be prohibited and would not be enforceable post termination of the contract. However, during the term of the contract, it would be valid and enforceable. Protecting confidential information, that's the next slide. So often it is very important, mainly in, where there is a lot of sensitivity on technology and on, confidential information, trade secrets, business know-how, concepts, ideas, financial information, IP, that parties seek to protect confidential information. There is no specific, what needs to be borne in mind is that there is no specific law in India that seeks to govern confidentiality of information. And this is, the law has has evolved over a period of time by way of judicial precedents. Since courts have from time to time upheld the principles of confidentiality under Indian contracts. So that gives a lot of comfort and a lot of assurance for foreign investors doing business in India that despite not having a law in place, courts as well as arbitral tribunals have upheld principles of confidentiality and have sought to protect confidential information and the misuse and leakage of confidential information between parties. So it is prevalent in employment contracts. It's prevalent in investment agreements, and the remedies for for breach of confidentiality is temporary or permanent injunctions, as well as damages which are sought under contracts. So this assumes a lot of importance, and we've seen quite a number of disputes arising out of a breach of confidentiality obligations. So it really warrants, and it's kind of important to have these robust clauses in the agreement to deal with confidential information. The next slide really deals with what is excluded from the purview of confidential information, which is pretty standard across the board. That is information which is in the public domain, or which becomes available to the public, or which is needed to be disclosed pursuant to a judicial order or to a judicial authority. So the next slide it deals with dispute resolution, which forms a very integral part of any contract, and particularly, it assumes a lot of importance for foreign investors wanting to do business in India. So historically, and even now, court proceedings before the courts, unlike in the US, courts in India, it can be a long drawn and time-consuming and expensive affair. And that has only escalated in the wake of the pandemic, and the cases being built up over a period of time before all the courts. That's not only the Supreme Court, but also the high courts, as well as district and civil courts in India. So often what we have seen is that, and what we recommend as well, is that parties do resort to arbitrations and have arbitral agreements in their contracts. I would like to mention, although, that even though you may subject your contract to a dispute resolution by way of arbitration, it is important to note that increasingly judges in courts are becoming more and more commercially savvy. They are, being qualified from reputable international colleges, and so the strength of the judicial system is very reassuring, and the qualifications are very reassuring. So what we do recommend to clients is that have the contract governed by an arbitration, so that it's speedier, more effective. However, we always advise clients to include a clause in the arbitration agreement so that both the parties, or any of the parties to the contract, can seek interim release before the courts of law. So the courts of law can be approached only for interim, important temporary injunctions, and that is very forthcoming, and in fact that is speedier than what it would be forthcoming if you would go before an arbitral tribunal, because what you would need to do is that you would have to constitute an arbitral tribunal, appoint an arbitrator, and thereafter submit your case for seeking a temporary injunction, which is not the case if you would have this stipulation in your contract, which allows either parties to approach the courts only for the purpose of seeking interim and temporary reliefs. So the remedies for breach of contract, again, an important point is that in litigation or in arbitration before the courts or before an arbitral tribunal, I think the thumb rule is that actual damages are only awarded. No consequential or indirect losses or damages are awarded. Well, we can have the concept of liquidated damages, preconceived damages in the contract. We can have clauses relating to limitation of liability also in contracts, but at the end of it, actual damages is what is going to be awarded by either the court or the arbitrator. So that needs to be borne in mind, and we have to prove that an actual damage has occurred and has been caused. So more often than not, we are seeing that language in claims and losses and definition relating to claims and losses, where we are including special consequential damages as well as actual damages. So we do retain a broad language for it to act as a deterrent. But I think the principle that needs to be borne is that at the time of enforceability, it will be only the actual damages that would be awarded by either a court or an arbitrator, and not inconsequential or remote or indirect damages. Now, going on to the next slide, limitation of liability. You can, as I mentioned, put in limitation of liability clauses. It is recognized by courts, as well as it is enshrined under the Indian Contract Act, as well as the Sale of Goods Act, which permits parties to limit their liability. Okay, so it is forthcoming not only in contracts governing sale of goods or movement of goods from one place to another, but also in we've seen these clauses coming up to be in investment agreements as well. There are certain, if this limitation of liability clauses are held to be unconscionable in nature or against public policy, then that can be disregarded by the courts or by the arbitrator. And as well as if these limitation of liability clauses are if there's a fundamental breach of a contract, then these limits on liabilities would not apply, and that would be struck down by and would not be recognized by the court or an arbitrator. So that needs to be kept in mind if we are having a limit on liability clauses. The next slide, indemnity, another very crucial point and another very crucial aspect in commercial contracts. So again, it not only includes a broad encompassing clause, which also provides for direct claims as well as third-party claims. And the point needs to be borne in mind is that, again, actual loss is going to be awarded. Another important phenomenon that has come into being a couple of years ago under the foreign exchange regime of India is that indemnity to an extent of 25% is only permissible for cross-border contracts. So that needs to be borne in mind. Otherwise, a special permission needs to be taken by the Reserve Bank of India at the time of actual remitting of monies. And what we have seen that permission is not forthcoming. So often what we have advised clients in this regard is that to really overcome this rule, if there is an Indian operating entity of the foreign client in India, we have in fact urged clients to make that entity a contracting party and to have all indemnity payments being directed to the Indian party. So that would not involve this 25% rule in any manner. So that needs to be borne in mind. And also with the coming into being of this rule, I think what is of utmost importance is that we need to be sure about the company, the target that we are investing in. So all the more, deep dive into due diligences and to uncover and to resolve any of the issues and to remedy those issues as a CP or as a closing condition prior to the investment in the target. That assumes importance. So I think I've already touched upon a bit of this slide in terms of damages. Again, to sum up that, we can have liquidated damages as well as unliquidated damages. We can have a foreseeable damage also included in the contract. We can have liquidated damages. We can have pre-estimated damages included as a monetary value or as a formula. But at the end of it, it's only direct damages and actual proven damages that would be awarded either by a court or an arbitrator. So certain on the next slide, certain intellectual property law considerations. We need to bear in mind a very important rule is that for either IP, that's either patent, copyright, or trademarks, the creator is the owner of the IP. So it assumes a lot of importance to have robust clauses which assign that property and that IP to the employer. We have seen contracts, and it's kind of standard now to include a works for hire concept in employment agreements as well as other commercial contracts to have the IP assigned from time to time by an employee to the employer. So in case of patents, again, just to sum it up, any patent created by the employee or an independent contractor is the property of that employee or the independent contractor unless it's assigned, okay? And a deed of assignment is required to be executed in writing and be registered with the patents registry. And it has to specify the nature of interest in the patent that is being assigned. That's important. Copyright, again, it is owned by the employee or the independent contractor until such time as it's assigned. And a deed of assignment must be executed, but it need not be registered with the copyright board. And it has to identify the rights and the scope and extent of the assignment and the amount that is involved for the assignment. Again, trademarks also, the point is for trademark is that it need not be mandatory registered in India. And the deed of assignment of a registered trademark, it must be registered with the trademark registry. And the deed of assignment is required to be registered with the trademark registry, but trademarks per se, they don't need to be registered with the trademarks registry in India, because India recognizes the well-known trademark and the principles of trans-border reputation concept. So that should be borne in mind. Now, we move on to the next slide in terms of employment law considerations. So there are certain things, the certain clauses which really need to be kept in mind whilst drafting employment contracts. And what needs to be kept in mind that employment law, there are certain key legislations at the central level, as well as there are certain legislations at the state level. Although I would say that the central legislations are by far more and more important statutes to be kept in mind. State legislations are important, but those are only for a few matters that need to be really kept in mind for. The applicability of employment laws would generally depend on the nature of business of the employer and where the location of the employer and employee is there, so that it is determined that which states or which of the states of India's employment laws would be applicable for the business. It also, it kind of hinges upon the number of employees that are being employed. So as a matter of fact, if there are less than 20 employees in a business or in an organization, then you can do away with complying with certain mandatory registration requirements, as well as certain key statutes. Now, an important point that needs to be borne in mind is that at-will termination of employees which are not in a managerial or a supervisory capacity, that is of actual workmen, that's not going to be possible without a retrenchment compensation and a notice period pay. So that needs to be kept in mind whilst drafting employment agreements. So moving on to the next slide. So there are three types of employment arrangements in India, which is, an employment contract, an independent contractor agreement, and an outsourcing agreement. So an employment agreement is between an employer and an employee, typically a master service servant relationship. And in an employment agreement, you would require to comply with all employment laws. Unlike in a situation of an independent contractor agreement where it will be solely governed by the terms of the contract and you don't need to really bother about compliance of a whole host of employment laws of India. And another arrangement that is typically seen in India is the outsourcing arrangement, where you would have contract employees from a contractor, and that the business owner would have an agreement with the contract labor provider, that is the contractor. So and in that case, the entity would not need to really comply with any of the labor registrations except for the Contract Labor Regulation Act. So what we have seen is there are a lot of considerations weigh in terms of determining whether to employ employees or to go in for independent contractors or to go in for an outsourcing arrangement. Now, out of experience, what we have seen is that for capital intensive industries, we have seen a lot of employees being hired through an outsourcing arrangement. What we have seen in tech industries, the tilt is more towards appointing independent contractors, and really for important key personals, then people really go in and employ those individuals as employees. So it's really a mix and a hybrid. But what we've seen that is that business owners really tend to resort to either an independent contractor agreement or an outsourcing arrangement with a third party provider of employees. So that's what we have seen happening out here. So the importance of employment contracts in India, that's the next slide. We need to lay down confidentiality provisions. Often that can be misused. So it's important to have robust confidentiality provisions. Also, we need to provide assignment of IP, which is again very, very critical. So we've often seen that arising out of due diligences in India is that there are no assignment provisions under the contract. So therefore, what we have to do is that typically have all the assignment agreements in place as a condition precedent or as a closing condition prior to closing the deal. So it's important to have assignment provisions from the employees to the target entity, and if there is an intercompany services arrangement between the target company and the US parent company, we need to see that the assignment is effective even from the Indian company to the US company. So that is also something that needs to be borne in mind. Also, in employment contracts, as I earlier mentioned, it assumes a lot of importance to have robust non-compete clauses to enforce those clauses through an employment agreement, because as I mentioned earlier, typically non-compete provisions are not enforceable in investment agreements and in share purchase transactions in India. Antibribery compliances assumes a lot of importance whilst doing business in India, more so since ever since the globalization has taken place, a lot of the businesses have been professionally run and are professionally managed. But India being a historical promoter-driven economy, and there are a lot of companies which are still promoter-driven, promoter-owned, family-owned companies, which do not often comply with the Prevention of Corruption Act, which is the anti-bribery regulation in India. So we need to have robust reps and warranties provisions, as well as what we have suggested to clients and the US clients doing business in India is to have adopt manuals, which really amalgamates the provisions of the FCPA with the Prevention of Corruption Act, and to frame robust training manuals. We have also conducted training of employees in India and educating employees, and also done periodic audit from time to time to check if there are any leakages in the system on the point of violation of any of the anti-bribery laws of India. So there are some differences which we have highlighted between the Prevention of Corruption Act and the FCPA that could be borne in mind. The Prevention of Corruption Act criminalizes both giving and accepting a bribe, and so there are no mitigating factors in terms of due diligence and compliance programs to mitigate any non-compliances under the Prevention of Corruption Act, unlike in the FCPA, where if you have exercised diligence, you can kind of build a defense around that. There is no concept of grease money or facilitation payments under Prevention of Corruption Act. So it's a complete embargo of any payments being given to government officials. Unlike in the FCPA, where certain amount of facilitation payments are permitted. But on the flip side, I think as compared to the FCPA, the Prevention of Corruption Act still needs to be more robust in terms of its enforcement and in terms of the penal consequences, which are not that significant as compared to what it's under the Foreign Corrupt Practices Act. Now, coming on to execution formalities, what we have in India is that we have a digital signature in place, of individuals who can have a digital signature which is issued by a ministry, but that signature can be affixed only on certain corporate documents and certain filings to be made before certain statutory authorities of India. So besides a digital signature, there is no electronic signature which is recognized in India for execution of contracts. So as a result of which, what we have seen is that contracts are executed by hand, in wet ink. And although what we've seen is that these signatures can be exchanged by fax and email, so that's permitted, and you need to have a stipulation in the contract which permits you to exchange execution versions on fax or email. Another important point on execution is that in India we do have a stamp tax, or a stamp duty that is leviable under most commercial contracts, and that stamp duty varies from state to state, and it's more of a state subject, although there are certain stamp duties under the Indian Stamp Act, which is a central subject as well. So, it is, a thumb rule that needs to be borne in mind is that, stamp duty payment is not really mandatory, but if we have to enforce the contract before a court of law, an unstamped agreement is not admissible. So at that time, we would need to stamp it with a penalty, as well as the requisite amount of stamp duty. So the point is that if there are contracts, between say a related party like a US parent and its subsidiary in India, it's not required to really stamp that document, because very less likelihood of any enforcement or litigation arising out of that. But any other contract with third parties, the advice would be to have it adequately stamped so that that can be admitted before a court of law or before an arbitral tribunal and be enforceable. Another concept in India, which is again a central concept, is of registration of contracts. So this is a phenomenon only for contracts for real property and immovable property, and not for other general commercial contracts. So it's essentially admitting execution of those contracts before the registrar at a state level for registering immovable properties. So if an entity if a foreign entity having its base in India, a subsidiary in India wants to lease or wants to purchase immovable property, then this registration would be forthcoming, and this execution formality will be forthcoming before the registrar, since it involves registering of immovable property. So essentially what this registration ensures is that with this registration in place, the land records are mutated in favor of the purchaser or in favor of the lessee. So it becomes very evident from the land title and land records that that this person or this entity is mutated in those land records as the owner or the lessor of the land. So that brings me to the end of this presentation, and I'll be happy to take any further any questions that one of y'all may have. Thank you.
So this is Carrie from the ACC, and I see a question that's come in from the chat from Volker. So the question is, do these exceptions to liability limit and indemnification also apply if a contract is governed by foreign law and we have arbitration in a neutral venue? Will India refuse to enforce the arbitral award under the New York Convention?
Sure, this would be applicable regardless of whether you have the New York seated arbitration or whether you have the contract as per the Indian Arbitration Act, because this emanates from a foreign investment, foreign exchange regime and a foreign exchange stipulation under the Foreign Exchange Management Act of India. So yes, we need to be mindful about this indemnification provisions. And just to add to that, bankers are, they will not remit proceeds unless there is an arbitral award in place. So we need to be mindful about this concept on indemnity. The point that I want to add to this is that if you have indemnity proceeds or claims exceeding 25%, but that is the point is that if that is granted by a court or an arbitral tribunal, then that could be forthcoming and could be remitted to the international party overseas.
Okay, thank you. Another question just came in. Are contracts for software development or other intangible property governed by the Indian sale of goods law or regulation?
So yes, tangible software, yes, it will be governed by the Sale of Goods Act. Although, I think, the point is that a lot of these contracts are now governed as per international principles, So the Sale of Goods Act does provide for, confidentiality provisions, as I mentioned, so limitation of liability. So yes, that would be predominantly be governed by the Sale of Goods Act, as well as, other provisions on non-compete confidentiality and all of that, which is also from the Indian Contract Act.
Great. Another question came in during the registration process. When does it make sense to contract with your company's US entity versus your Indian affiliate? What are some of the benefits and disadvantages?
So again, what I mentioned, during the so it's kind of beneficial, if we are entering into a contract with the the Indian subsidiary, okay, rather than the parent, because again, from that indemnity provision standpoint, it's easier to get the money paid and get the monies to that Indian subsidiary, because that would not involve foreign remittance of the payment outside India. So that is a key driving factor on having an Indian party being interposed in the agreement. Well, what we have seen is that, and what we have suggested to clients is that if you are having a contract with a third party, so have both your US entity as well as your Indian operating entity be parties to that agreement, so that for the purposes of enforceability and for getting the payments, it's easier to remit payments to within India to the Indian subsidiary.
Thank you. We have also had a question about best practices or conventions for payments between Indian entities and US entities and handling of exchange rates.
Sure. So the best, I think what needs to be borne in mind is that India allows for free repatriability of monies on which taxes have been paid. So a critical point is that we need to bear in mind is that taxes need to be paid in India by the subsidiary, and then the subsidiary can remit those amounts out by way of dividends to the foreign entity. So there is no fetter or limitation on remitting payments from an Indian sub to the parent company, provided taxes have been paid in India.
Thank you. We have a question now about employees. Does India have a test similar to California's ABC test to determine whether a worker is classified as an employee or a contractor?
So we don't have strictly on the lines that you just mentioned, but what we have a test is that, what we generally grapple with is that whether a workman is considered to be a workman or a non-workman, okay? Because that is a key determinant factor under Indian law, because as I mentioned, workmen are entitled to protection under employment statutes, whereas a non-workman, that is typically a person in managerial and supervisory role, they would not be entitled to any per se benefits under employment statutes, and their terms and the terms of the employment would be governed by what is mentioned in the employment agreement.
Thank you. Switching over to contracts, what contracts require special paper, and when is an electronic or soft copy of a contract acceptable in the tech and telecom industries?
So soft copies are acceptable. As I mentioned that, we don't recognize, Indian law doesn't recognize electronic signatures besides digital signatures. Digital signatures can only be adopted and can only be affixed on certain documents that are required to be filed before judicial authorities. But to answer the question that yes, soft copies are recognized. We can exchange signatures by handwritten signatures by fax or by email, and what we often follow is that at the time of signing, we we have this papers exchanged by emails or over fax, and then thereafter circulate the documents to each of the parties for full vetting signatures. And but I think even between that, I mean, even if that is not, if we could enforce contracts even on the basis of soft copy signatures.
Okay. Great. And this is somewhat a broad question, but it has to do with data privacy. Are there some basic rules when contracting in India that in-house counsel here should be aware of when they're doing business in India? What are sort of the top things to be aware of from a data privacy standpoint?
Sure. So there is, there is no separate data protection law, okay, which governs protection of data, but those principles are enshrined under the Information Technology Act, which provides for a confidentiality of data being maintained. But what we do recommend is that we need to have privacy policies in place, seek consents from time to time for disclosure or for usage of or mining of data. So that becomes very critical, and so clauses around that need to be put in under contracts.
Okay, great. And for a company who is looking to contract to India for the first time, what are some of the key preparations that need to be done before actually making that move to begin contracting in India?
So I think, the first key steps would be really to, understand the cultural mindset, to see the credibility of the party that you are doing business with, because that assumes key importance. That would be even for any other jurisdiction worldwide, But in India, as I mentioned, a lot of the companies would still be promoter-owned, promoter-driven, although there are a whole host of professionally run, professionally managed companies. What you would need to be mindful also before, besides the cultural issues, would be also on the anti-bribery compliances, as well as corporate compliances, employment compliances, payments made for taxes. Those are certain key important aspects in the legal frame of things to be kept in mind and to be investigated whilst doing business in India. So because all those things would, from a from a legal due diligence standpoint, would give a lot of comfort then for the foreign investors to step into India.
Great.
Also, just to add to that point, I think what we need to be mindful is that there are certain employee records, certain documents, certain corporate filings which would not be complied with. Okay, but that's pretty much a regular phenomenon in India, but which can be really rectified at the condition precedent stage or at the closing stage, prior to making the investment in India. So it's kind of, what I would say is that it's nothing to get alarmed about, but things that could be rectified before the actual investment is made.
Okay. And that actually leads into the next question, which is about issue spotting. So as companies begin to contract in India, what are some key risk areas that you've seen US companies faced with when engaging with India? Like, what are some things to watch for in particular?
Sure. So again, breach of confidentiality provisions, then data protection, non-compete, dispute resolution mechanisms, then ability to have interim reliefs in place, which is what I was suggesting in the presentation, that although you should have your entire contract being governed by an arbitral mechanism or an arbitral agreement, but please have a clause to specify that interim reliefs can be sought by both the parties before a competent court or tribunal in India. So these are the key things to watch out for whilst really stepping into India.
And is there anything on the horizon that you see potentially coming from a legislative standpoint, or anything that could have impact doing business in India? Or is there anything you're watching for?
See, I think we do have a very robust data protection bill on the anvil, okay, because that would further comfort foreign investors. So that is something that we are waiting for the legislature to enact.
Mhm.
Another point is that the tax laws need to be simplified, okay. uh, the tax laws are too wide in an ambit, but the comforting factor is that over these recent years, what we have seen is that there are a lot of key judgments and key pronouncements and key rules that have been enunciated on the tax aspect that have comforted foreign investors, and thereby giving more confidence for foreign investors to do business in India. Also, what we have seen is that the government is really on the forefront and on a very and on a war footing to really have proper laws in place, and make important amendments to certain old archaic laws to have a very robust banking system, a securities regulator in place, and which we do have, which they have been very resilient, in terms of the downturns that the global economy has faced. So what we have seen is that the government has been very proactive to step in at the right time and to understand problems and issues of foreign investors and to rectify those in a very time-bound manner.
Okay. Well, that is all the questions that we've had come in for this session. If you have any sort of parting thoughts for us, please let us know. Is there anything you kind of want to leave us with?
Sure. So as I mentioned, I mean, India is on a growth trajectory. Okay. Ever since the pandemic and the eruption of this pandemic, we have seen a lot of businesses move in from China as well into India, because people have come to realize that unlike issues that can arise in China, what India has been is that it's a very resilient economy, and it is like what you see is what you get. So what you are, it's like an investment destination which provides a lot of comfort for foreign investors. We do have a very, very well regulated legal system, and that provides a lot of comfort for foreign investors to do business in India. And what we've seen is that foreign investors have been very successful. We have had a lot of foreign corporations, doing business in India since the past 3 to 5 decades, and they are still continuing to go strong in India. So all in all, it remains a very, very positive investment destination, given the talent pool that is available in India, and given the robust legal framework that is prevalent in India.
That is great. Well, thank you very much for this presentation today, Rukshad. We have not had presentations about doing business in India until you came onto the scene back in September, and we have benefited from both that presentation and this one. So we really appreciate that. The CLE certificates and a copy of the presentation will be sent out to you in the next couple of days, so you don't have to take copious notes, and we'll be posting the recording on our website as well. Thank you very much, and we look forward to seeing you again, Rukshad.
Thank you very much. Thank you. Pleasure is all mine. Thank you.